It's great to welcome to the program today Sanford Levinson, who is a legal scholar, professor at the University of Texas Law School, and co-author, along with his wife Cynthia, of the book Fault Lines in the Constitution: The Framers, Their Fights, and the Flaws That Affect Us Today. Sanford, so great to talk to you today.
I'm delighted to be here.
So to begin with, for people who maybe aren't familiar with the genesis of the Constitution, what was going on in the United States that prompted the founding fathers to realize that the Articles of Confederation were in some way not working or falling short, and that writing a constitution was something that made sense?
Right. There are three principal things. First of all, the so-called national government, and I use that term advisedly, was incapable of getting any money. What they could do, in effect, was to ask the states to contribute. But by 1786, I think they were contributing something like a total of $636. So that's the first thing, no money. Secondly, there were fears of various military attacks from a variety of European countries, but also from a variety of Indian tribes, many of whom, for very sensible reasons, had supported the British during our secession from the British Empire. And so there was real concern about the ability of this new country to defend itself. The third thing is that there were trade wars, which is something we're familiar with today in an international context, but there was no established notion of free trade among the various states. And there was some genuine hostility between and among a number of the states, so that people like Alexander Hamilton and others described the system under the Articles of Confederation as, quote, imbecilic, unquote, and something had to be done.
When the transition from the Articles of Confederation to the Constitution took place, how much discussion do we know, how much discussion there was about writing the Constitution in such a way to indefinitely account for however society might change? And the reason I ask that is that now there is a big debate over to what degree do we need to be amending the Constitution on an ongoing basis to account for how drastically life has changed today from when it was written. Was there much discussion of accounting for that at the time of its writing?
That's a terrific question. I think that the most accurate answer is no, that the first Constitution, that is the Articles of Confederation, lasted a grand total of 6 years. I think that if you could have interviewed the framers, they would have been thrilled to be told that the 1787 Constitution would last 50 years. I think if you had said, well, you're really writing something that should last forever, I think they would have said, that's crazy, in part because they were extremely aware of what they repeatedly called the lessons of experience and the need to update government in terms of those lessons. Cynthia and I do not engage in founder bashing. We think that the founders, by and large, were admirable people trying to respond to what they thought were the chief challenges of the day, and that they weren't utopians. They were trying to develop a document that could get us through the next several years, where several might mean 25 or 50, but they expected amendment, and quite frankly, I think a lot of them expected new conventions. Article 5, which is the amendment article, explicitly allows for new conventions. And I think that most of the framers would be astonished to be told that there's been no national convention since 1787, whereas there have been over 230 state constitutional conventions since 1787.
So there is the view from some that it is immensely difficult to amend the Constitution. So my question is sort of a two-part question. The first part is, how do you assess the difficulty of amending the Constitution in the context of sort of modern society? And number two, If indeed the founders were so welcoming or expecting of significant amending of the Constitution as the country changed, why did they set the level of difficulty that they set?
Right. Another great question. What they faced in 1787 was an Articles of Confederation that required unanimous consent of the state legislatures of every state. So, from their perspective, Article 5, which requires, quote, only, unquote, three-quarters of the states to assent to amendment, was a big improvement. Secondly, Article 5 worked in the first, let's call it 15 or 20 years. We got the Bill of Rights in 1791. 12 amendments were sent out. 10 of them were ratified. We call them today the Bill of Rights. In 1800 or 1801, the problems, to put it mildly, of the way we selected presidents was revealed in the tie between Thomas Jefferson and Aaron Burr. And we got the 12th Amendment, which changed things for the better, though not enough as far as I'm concerned. And I'm skipping the 11th Amendment, which is much more esoteric. But in 1793, the Supreme Court issued a very controversial decision about states' rights, and it was reversed. So if you look at our early history, you could say, well, no, three-quarters is a lot, but the system is more or less working. In the modern world, three-quarters of 50, where you have the distribution that you now have of small states, and indeed very small states, and not only large states, but very large states, and a far, far more polarized country than even was the case in 1787, it has become functionally close to impossible to amend the Constitution. So, political scientists have looked at this, and some have said that the United States national Constitution is the most difficult to amend Constitution in the world. And one of the things we talk about in our book, and frankly, I think one of the things that is especially valuable about our book, is that we look not only at the U.S. Constitution, but also at the fact that every state has its own constitution. There are 51 constitutions in the United States. And if you look at the state constitutions, they are all easier to amend than the national Constitution. So it's not the case that the American people are reluctant to amend their constitutions. In fact, the typical state has had close to 3 different constitutions over their histories. Rather, we have a peculiar religious-like veneration of the national Constitution that makes it almost unthinkable to talk about amending it. But even if you do think of amending, you then come up against the concrete reality that it's extraordinarily difficult to get 2/3 of each House of Congress. And then even if you get it, it's even more difficult to get 3/4 of the states.
So one of the areas that is of a lot of interest right now because of the current administration is the census and how should it be carried out? What is really the underlying purpose of the census? From a sort of constitutional historian perspective, what was the point of establishing the census to begin with?
Yeah, census is an extraordinarily interesting part of the Constitution because you can make an argument that it's really one of the very, very few things Congress must make sure is done. The other is actually setting up a Supreme Court of the United States. But, for example, setting up circuit courts or district courts, that's optional with Congress. It's optional for Congress to declare war or not to declare wars, et cetera, et cetera. But the Constitution requires that a census be held every 10 years. And the reason is deceptively simple. It's the House of Representatives, that the House is allocated more or less proportionately, unlike the U.S. Senate. And so if you're going to have a major branch of Congress where representation is a function of the population of the states, you have to know the population of the states. It's really as simple as that. And it's every 10 years because the framers were smart enough to realize that the United States was a dynamic country. There would be lots of settlement. There would be people moving around. So you couldn't necessarily depend that the population of Virginia in 1790 relative to the population of Tennessee would be the same in 1800 or 1820, et cetera, et cetera. So the Constitution requires every 10 years without exception.
Interestingly, in my reading, although it requires it, it's not clear what the penalty would be and to whom it would be assessed if the census does not happen as scheduled. Is my reading correct of that?
Well, it's one of those things. John Marshall referred to the Constitution as a great outline. And so there are things that are specified. One of them is you got to have a census. But again, the question you ask is a very shrewd one. What if the president says, I don't think so? Mm-hmm. Then what do? Do you charge the president with violating the law? Well, actually, this morning is being spent on the Mueller hearings and hearing Robert Mueller saying over and over again, the Justice Department says you can't indict a sitting president. So could you impeach a president for refusing to take care to enforce one of the most basic obligations of the national government, which is to conduct a census? I think the answer is yes. But I think it would require a sense of national outrage led by Congress that the president is being derelict with regard to one of his most fundamental responsibilities, which is to make sure that the House of Representatives is fairly apportioned.
Yes, and in today's hyper-partisan climate, it's hard for me to imagine that there would be that level of unitedness around that particular issue, but it remains to be seen.
Right. I think you're right.
We've been speaking with Sanford Levinson, who's a legal scholar, professor at the University of Texas Law School. The book co-authored with his wife, Cynthia, is Fault Lines in the Constitution, the Framers, Their Fights, and the Flaws That Affect Us Today. Sanford, really a pleasure having you on today.
My pleasure.